Judge Adams, so let's listen in.
And was able to, from a close vantage point, observe that the vehicle was occupied by one person. And that was an individual who would have been wearing a hooded sweatshirt and appeared to be of either Hispanic or Middle Eastern descent. That would have been essentially the extent of his testimony. He would not have thought terribly much about that at the time. Subsequently became aware of the fact that Rusty Sneiderman had been shot and that a silver van had been seen leaving the scene. Then subsequently contacted the police and notified them of that fact. We would have been seeking to elicit that testimony to show, one, to support the inference, to support the statement that Andrea Sneiderman had made to the police that in fact Hemi Newman was in fact stalking her, and also to provide an inference that it was Hemi Newman on the side of the house on November the 10th, 8 days earlier, who had been present at that time. The court will recall there was testimony that a Hispanic man was found sitting by the side of the house. As the court will also recall, during the course of the original statement that Mrs. Sneiderman made to the police, she emphasized to the police her belief that there was a connection between that particular incident and the death of her husband, and tried to discourage the police from investigating business contacts or folks who had done business with her husband. We offered that to support the inference that that in fact was Hemi Newman, and also to show that she was the one who was not leading the police astray. As a practical matter, it was the police who were leading themselves astray in the course of their investigation. I would also note for the record that Investigator Potter had prepared a sworn affidavit which was filed in the Superior Court of Fulton County, which contained a statement that Hemi Newman was the person on the side of the house on November 10th of 2010.
All right, Mr. James, who's witness?
Your Honor, the problem, and Mr. Clegg said a lot, but the problem, I can make it very short, is that it doesn't support the inference that it was Hemi Newman on the side of the house. The only testimony in this trial is that somebody on the side of the house had a beard. They looked like a Hispanic male. There's nothing else that's come out that said Hemi Newman was even in America on that day, more or less at the defendant's house on the side of the house. Second of all, the defendant didn't see anything. Her husband saw it. So I don't really understand how the fact that somebody had a van and looked Hispanic and had a beard, whether that beard was real or fake, supports an inference that it was in fact Hemi Newman when there's no evidence presented in this trial that, you know, Hemi Newman was that person. So it's not relevant.
All right. Anything else for the record?
The only thing I would note for the record, Your Honor, is just so we're clear, I don't believe Mr. Gay would have said the individual had a beard on at the time, and I don't believe the evidence would have been that Mr. Newman had a real beard. So I don't know if that's terribly germane to anything one way or the other. I just wanted to clear that up. So no, I have nothing else on that subject.
All right, Mr. James, anything else for the record?
Yes, Your Honor. The only other thing that I would add, in light of counsel's admission on the record, it makes it even more irrelevant because he's saying, I don't believe that he had a beard. At least in the sketches that we have, the individual has a beard. If Mr. Gay saw someone and they didn't have a beard, it doesn't even support an inference.
Anything else for the record from the defense?
Nothing else for the record, Your Honor. Excuse me, nothing else for the record. Yes, sir.
Anything else for the record for the state?
No, sir.
All right. Let me, Kelly, we're off the record. The lawyers, this approach momentarily, just arranging some things.
Off the record again, says Judge Adams, but we are not done yet. Coming up on 5:30 right now, joined by Jay Strongwater. Jay, what's going on right now?
Right now they're debating, or the defense is asking the judge to reconsider the limitation of the neighbor's testimony. Mr. Clegg has made something called a proffer. He's made representations of what his questions and what the testimony would have been if the judge would have allowed it. So there's a detailed factual statement. Had you allowed me to ask this witness questions, he would have testified that he saw a fellow on the side yard, that it was called in and the DeKalb County or Dunwoody authorities didn't do their job. That's the inference they want to say. The judge has already ruled that it doesn't come in, and so once again what he's saying is appellate court, if there's a conviction, we think the conviction was wrongly entered because we were not allowed to introduce this type of testimony for the jury to hear.
I got a text from somebody who works in the law business who wanted to know if you've ever seen a judge who has a kill button on the audio, the way Judge Adams does on this, and essentially is playing judge and also editor, in terms of deciding what goes in and what goes out.
I have not, and it's interesting that they're having a sidebar. Sidebars are generally held because the judge does not want to excuse the jury and he wants to talk to the attorneys about a legal issue. The jury's not in the courtroom, and it's interesting that the judge wants people at the sidebar to have this discussion. There's really no necessity other than to keep the public unaware of the exchanges that are going on.
Headline of this day remains the possibility, the specter, that Andrea Sneiderman may be testifying in this trial. Would we see her tomorrow, or would it be on Thursday if that decision is ultimately made to do?
It would seem that the rabbi's testimony is a logical end to the witnesses, which would drive the question tomorrow where the judge will ask Andrea Sneiderman, do you wish to testify? If she says, no, I don't, tomorrow's trial will come to an abrupt halt. There may be something called rebuttal testimony, but the jury will be excused. The parties will talk about how the jury should be instructed, and they would probably start fresh Thursday morning so they could have a unified closing argument, jury instructions, and the jury gets to start to deliberate.
So then you think tomorrow morning at 9 a.m., though, we'll have a much better sense of how this is going to play out?
Yes. Now, the witness on the stand now is not done. We have no idea how much longer he has on direct. The state, of course, has a chance to cross-examine. So you figure about 10:30 or so, if he's the last witness, then there'll be this dramatic moment of, Ms. Sneiderman, do you wish to testify? Have you been advised by your attorneys? What is your free choice as to what to do?
Andrea Sneiderman has been more active today in terms of the pen and in terms of papers, and if you didn't know better, would assume that maybe she was another attorney simply sitting at the desk. How important is her counsel at this point?
They're important. Again, this is a team effort. Ms. Sneiderman knows the witnesses that are testifying. She's had private conversations with these witnesses. The attorneys have interviewed these witnesses, and she may feel that there's certain salient points that they're not bringing out, and she wants to remind them to do it. Also, tonight they're going to caucus in order to prepare for closing argument, and she's making notes about what she thinks has made an impression on the jury.
There's one of our viewers who says, great coverage today, enjoying Jay Strongwater a lot. In fact, the practical, direct approach to legal issues as opposed to providing the regurgitation of the law is something that has made this experience over the last couple of hours enjoyable. So tip of the cap to you from one of our viewers.
Thank you, and I'm going to thank all my friends that have been sending messages to Jeff, complimenting me, and dinner will be a place to be determined.
There also has been, the rabbi has gotten a lot of attention too on Twitter and social media as well about his role in all of this. Is it unusual to have someone such as he on the stand?
Yes. First of all, there's a privilege. In fact, the statute says that clergy are incompetent witnesses. So it would require the rabbi to give up his privilege. It would also require Ms. Sneiderman to give up her right to keep her confidential communications away from the jury.
Is that to appeal to the spiritual sensibilities, if there are such things among the jurors?
Yes. He's a man that hopefully the jury will look at and say he has credibility. The weight of his testimony supersedes the weight of other people whose testimony has been contradicted or in dispute.